2.5 centuries ago, the federal criminal law was a short list of truly bad acts: treason, counterfeiting, piracy, and almost everything else was left to the states. The young United States had no federal common law of crimes, so new federal offenses had to be explicitly created by Congress. Over time, however, Washington, D.C. developed an insatiable appetite for defining new misdeeds. The 20th century saw an explosion of federal agencies and regulations, especially during the Progressive Era and New Deal, each empowered by Congress to fill in the details of broad statutes. Often, Congress not only authorized regulators to write binding rules, but also made violating those rules a crime. In practice, this meant unelected officials could effectively create criminal offenses by drafting regulations, a twist of constitutional design that hasn't been lost on critics. The result today is a vast regulatory state where an American can commit a federal crime without ever realizing it by transgressing some buried provision in the Code of Federal Regulations, which we abbreviate as the CFR. To grasp the scope of the problem, consider the numbers. The CFR has grown into a monstrous labyrinth of rules, roughly 175,000 pages. And no one truly knows how many acts it criminalizes. The Justice Department itself gave up counting long ago. One estimate puts the number of federal regulatory crimes in the hundreds of thousands. By comparison, there are only about 5,000 crimes in federal statutes in the U.S. Code. This overgrowth has led to overcriminalization. Americans can be prosecuted for offenses that are technical violations of regulations, often unrelated to any immoral conduct. The situation has become, in the Trump administration's own words, absurd and unjust, giving bureaucrats a club to punish people who had no intent to do wrong. It's a state of affairs ripe for abuse, letting government lawyers target unwilling citizens and weaponize minor regulations against them. Absurd examples of regulatory crimes are found all over these regulations. If this sounds like hyperbole, the U.S. Code offers plenty of darkly comic examples of criminalized trivia that diverge from any common sense notion of justice. It is, for instance, a federal crime to misuse the character of Smokey the Bear or his friend Woodsy Owl, including Woodsy's slogan, "Give a hoot, don't pollute," without authorization. Sell margarine in Wisconsin, shaped like a cube rather than a triangle? Crime. At one time, that too ran afoul of the law. Andy Biggs highlighted absurdities in laws such as the ones that make it illegal to dress up as a postal service worker even for Halloween, or sell certain margarine unless it's shaped triangularly. The margarine law refers to a bygone regulation intended to distinguish margarine from butter, a prime example of archaic rules lingering on the books. Another notorious case saw federal agents prosecute a group of seafood importers for the manner in which they packaged lobsters. The manner in which they packaged lobster. The crime? Violating the Lacey Act by importing lobster in plastic bags rather than cardboard boxes, allegedly contrary to Honduran regulations. I'm not making this up, people. U.S. prosecutors charged the men with felonies carrying up to 8 years in prison for this packaging snafu, even though Honduras itself insisted no law had been broken. These examples may sound absurd, principally because they are, but they show a real phenomenon. Federal criminal regulations often stray far from the public's sense of justice or any will of the people. Against this backdrop of regulatory overreach, modern presidents have sporadically tried to prune the thicket of rules, or at least mitigate its harshest effects. President Trump has been especially vocal about the issue of overregulation and its cousin, overcriminalization. His latest executive order in May 2025 represents the culmination of a years-long crusade to dial back the federal regulatory state's punitive excess. To appreciate what this new order does, it's important to compare it to Trump's earlier efforts in his first term, including, but not limited to Executive Order 13771. Let's talk about Trump's mission against overregulation then and now. President Trump's approach to the regulatory state is oscillated between the dramatic and the wonkish, but consistent themes have developed. He seems to always continue to say there's too much law. In 2017, shortly after taking office the first time, Trump issued Executive Order 13771, titled Reducing Regulation and Controlling Regulatory Costs. This order grabbed headlines by imposing a blunt 2-for-1 requirement. For every new regulation an agency promulgated, at least 2 existing regulations had to be identified for repeal. In essence, 13771 treated regulations like Hydra's head: cut 1, cut 2 more for good measure. It's also set an annual regulatory cost cap, instructing agencies that the total incremental cost of new rules had to be no greater than 0, offset by eliminating old rules, otherwise required by law. 13771 was a broad deregulatory swipe. It was about sheer quantity and cost of regulations, not about their criminal enforcement. Agencies scrambled to comply, repealing or tweaking rules to meet quotas. By the metrics the White House touted at the time, thousands of planned regulations were withdrawn or delayed. And the growth of the CFR noticeably slowed in 2017 to 2020. For those who don't know, the CFR are the regulations that are implemented by agencies. The Executive Order 13771 did not distinguish between a regulation that carries criminal penalties and one that doesn't. A rule about, say, campground fees counted the same as a rule carrying jail time for violations. In short, the 2017 order's focus was bureaucratic weight loss, trimming the fat from the regulatory body, Ozempic, if you will. But it didn't address the core injustices of turning unwitting citizens into criminals. Trump's administration also took other steps in his first term that, while lower profile, hinted at concern over regulatory crimes. In October 2019, he signed Executive Order 13892, prompting the rule of law through transparency and fairness in civil administrative enforcement. That, paired with separate executive order on guidance documents, was aimed at reining in agencies' use of sub-regulatory guidance and ensuring people aren't ambushed by secret rules. It required agencies to publish any guidance they would enforce and not to spring new interpretations on people unfairly. While the executive order dealt with civil enforcement, not crimes, it reflected a similar ethos. Agencies should act transparently and fairly, not like Kafkaesque overlords. In the waning days of Trump's first term, the White House finally zeroed in directly on overcriminalization. On January 18th, 2021, literally 48 hours before leaving office, Trump issued Executive Order 13980, titled Protecting Americans from Overcriminalization Through Regulatory Reform. Its purpose was plainly stated: to ensure that Americans have fair notice of what regulations might land them in jail, and to focus on criminal enforcement on the most culpable individuals, effectively realigning America's priorities with the needs of the citizens, not just the needs of the state. Executive Order 13980 declared it official policy that federal criminal laws should be clear and understandable, and directed agencies to be explicit about any regulatory crimes, including the required mental state. It also urged shifting strict liability regulatory offenses, where no guilty intent was required, into the civil or administrative realm whenever possible. In effect, this 2021 order was a blueprint quite similar to the new 2025 order. It sought to inject common sense and fairness into the tangle of regulatory crimes. However, the executive order barely had a chance to get going. It was promptly rescinded by President Biden, who reached into its crib and snatched it in early 2021, along with several other Trump executive orders. Some may recall that executive order killing first day that Joe Biden had. The change of administration snuffed out this reform before agencies could implement its mandates. We never got to see its effect. Now, in May 2025, having returned to the Oval Office, Trump has issued a new executive order that resurrects and expands upon the 2021 effort. The title of this order, Fighting Overcriminilization in Federal Regulations, makes its thrust clear. In tone, it's arguably even more strident than the 2021 predecessor, referring to the status quo as absurd and unjust, and vowing to ease the regulatory burden on everyday Americans so that no one is transformed into a criminal for violating a regulation they have no reason to know exists. The 2025 order picks up where Trump left off, this time with the benefit of a full term ahead to see it through, barring any surprises. What exactly does this new executive order do? In substance, it directs the executive branch to dial back criminal enforcement of regulatory offenses in several concrete ways. First, it disfavors criminal prosecution of regulatory violations. What does that mean? The order makes it the policy of the U.S. government that criminal enforcement of regulatory offenses is disfavored. Not every violation of the CFR should trigger a SWAT team. Instead, prosecution should be reserved for serious, knowing wrongdoing. In plainer terms, the White House is telling agencies and prosecutors, don't charge people with crimes over regulatory infractions. Save the heavy artillery of criminal law for cases where someone truly knew their conduct was illegal and did it anyway, causing real harm. This is a sea change in attitude, an official recognition that just because something can be charged as a crime does not mean it should. I think we can all agree on that. Cracking down on strict liability offenses is the next goal of the executive order. The order plainly criticizes strict liability crimes. That's crimes where you don't have to prove a mental state. The regulations that impose criminal penalties without requiring any intent or guilty mind should not be enforced that way. Such offenses are generally disfavored. Agencies are instructed that if a regulation is a strict liability offense, meaning a person can be convicted even if they had no clue they were breaking the law, enforcement should lean towards civil penalties or administrative action rather than criminal charges. In essence, no more felony charges for honest mistakes in the regulatory arena unless there's no other option. Notably, the executive order drops a footnote to remind agencies of one of my favorite decisions and a case in which I wrote an amicus brief on behalf of administrative law judges, Jarkissi versus SEC. For like 3 years, I called it Jarkissi. And Judge Mulrooney informed me that I was making a mistake. But they dropped a footnote related to that case. And that case held that certain administrative enforcement actions might entitle defendants to a jury trial as opposed to an administrative agency hearing, which means that if you take them to an administrative hearing, they may request a jury trial in some instances. Now, the third thing that I want to go over with this executive order is transparency. And here we talk about the catalog of crimes. One of the most significant mandates is that each federal agency must, within 1 year, compile a public list of all regulatory offenses it has the power to enforce criminally, including the potential penalties and the required mental state for each offense. These lists must be posted publicly and updated at least annually. The executive order pointedly states that if an offense isn't published on the list, criminal enforcement of it is strongly discouraged. Let me repeat that again for those in the back. Within 1 year, there needs to be a public list of all regulatory offenses. Let's see how many times that gets kicked down the road. Hopefully never. The list must be posted publicly, a list of crimes. Could you imagine? Martin Luther posting a list of crimes on the doors of the Catholic Church. We're back to those days, and I do appreciate it. We should know what the crimes are. This is meant to prevent gotcha prosecutions where neither the public nor perhaps even the agency's own regulated community knew that some obscure rule carried a jail sentence. It's a bit of sunlight and notice which is what the Constitution requires. Notice. Everyone will be able to see it in one place. It can be challenged. The Attorney General and agency heads are instructed to consider whether an offense was publicly listed when deciding on charges or referrals. In short, no more secret crimes. I see a lot of gray there. This is going to be tough. Next, mens rea and clarity reform. The order tells agencies to spell out the mens rea, the intent, for each regulatory crime clearly, both in these compiled lists and in any new regulations going forward. If an agency issues a new rule that carries criminal penalties, it must clearly state what level of intent is required for a violation to be criminal. Moreover, if any new rule would create a strict liability crime, remember, no intent is needed. That rule is automatically flagged as a significant regulatory action, requiring higher review under the executive order. This creates a speed bump to slow down the creation of new strict liability crimes. Agencies are also directed to review existing crimes and consider adopting a consistent default mens rea standard. For example, presume that a knowing violation has occurred unless a law specifies otherwise, meaning the mens rea would be knowing, knowledge. If certain offenses lack an intent element, agencies might propose regulations or ask Congress to add one. The overall goal is to infuse the criminal regulatory landscape with the classic principle that crime requires a guilty mind. Guidance on when to refer for prosecution is the next thing addressed. Within 45 days, each agency must publish guidance for its enforcement personnel on how to decide whether a violation should be referred for criminal prosecution. The EO suggests common sense factors, the amount of harm or risk of harm caused by the violation, the financial gain to the violator, whether the violator is a sophisticated player who should know the rules, and whether there is evidence the violator knew their conduct was illegal. In other words, use your judgment. Don't refer every technical breach to the Department of Justice. Focus on the bad actors. The order essentially tells agencies to treat criminal enforcement as a last resort for the worst violations, not the first tool out of the box. Exceptions. There are some exceptions to this executive order. The executive order carves out the usual sensitive areas. Immigration, national security are not subject to these new policies. So no, this won't affect how immigration crimes or terrorism-related regulations are prosecuted. Those remain a world of their own for now, I would say. In sum, the 2025 Fighting Overcriminilization order is an attempt to recalibrate the federal enforcement machine. It doesn't erase any laws. The executive order can't repeal a statute anyway, but it directs the executive branch to enforce more humanely and sensibly. It's trying to draw a brighter line between true criminal behavior and regulatory oopsies. Compared to 2017's executive order, which basically was a broad mandate to slash regulations, the 2025 order is a targeted strike for a specific issue in the regulatory state, the overuse of criminal punishment for regulatory violations. Unlike the 2017 order, this one has a clear legal philosophical bend. It speaks to fair notice, mens rea, the injustice of punishing the blameless, themes more often heard in law review articles or from Federalist Society wonks than in executive orders. In a way, this reflects an evolution in Trump's anti-regulation agenda from cut the red tape to restore fairness and sanity. Of course, Trump's trademark bombast is still present, calling the status quo absurd, talking about draining the swamp of overregulation, but the focus is unmistakably on protecting the average people from obscure criminal traps. No doubt, people other than Trump were involved in the creation of this executive order, which is important to note. What the new policy means on the ground. What can defense counsel do with this new policy? Grand pronouncements from the Oval Office are one thing, but try to wave that in front of a federal judge and see how far you get. It's not going to work. The courtroom is a completely different place. For federal criminal defendants and those under investigation, as well as their defense attorneys, the key question is, how will this executive order actually be interpreted and implemented by line prosecutors and agencies? As a former prosecutor myself, I certainly can address the question as to how these executive orders are implemented. Some effects will be felt immediately in the way prosecutors and agents exercise their discretion. The Attorney General has been instructed to align DOJ's practices with the executive order. This means that U.S. attorneys nationwide are receiving the message that borderline criminal regulatory cases should be declined or handled civilly if the defendant didn't have a guilty intent. We expect internal guidance within the DOJ echoing the executive order. Don't seek indictments for technical, unintentional regulatory violations. This will likely be a part of the U.S. Attorney's Manual, which is published on the Department of Justice's website. As a practical matter, a lot of these cases might simply never be brought as criminal cases now, which is the point. For example, if an agency investigator uncovers a violation of a complex rule that resulted in minimal harm and appears to be an honest mistake, the new default may be to handle it with a warning or a civil fine rather than referring it to criminal prosecution. For defense attorneys representing clients in regulated industries, the executive order is a new arrow in the quiver. While the order doesn't create enforceable rights for a defendant, you cannot move to dismiss an indictment based on the fact that it violates an executive order or policy. It does, however, have some influence. Defense lawyers can and will cite the executive order in negotiations with prosecutors. And I say this for those criminal defendants out there who may be listening. You're not going to have success filing a motion to dismiss based on an executive order. This is a matter of policy, but much better to argue that a supervisor in the prosecutor's office is likely not going to have the staying power for a very costly and expensive trial that is misaligned with current government priorities. A savvy defense counsel might write a letter to the DOJ before charges are filed saying, our client acted in good faith and any violation here was inadvertent, with maybe some evidence. Pursuing this criminally would be contrary to the president's policy, which urges restraint in these circumstances. And again, support it with evidence. This is exactly what I will be doing for my clients. This kind of argument is weight now. It's pointing to the official policy of the United States that the executive branch itself should not be overly harsh. We can reasonably expect more cases to be resolved through non-criminal avenues, for instance, civil settlement, compliance agreement, or at worst, deferred prosecution, rather than straight criminal indictment, when the violation is not egregious or intentional. Defendants who are charged despite the executive order will still have to fight the charges in court under existing law. I don't expect many, if any, voluntary dismissals based on this new guidance. But even then, the executive order's emphasis on intent could subtly affect things. Prosecutors mindful of policy might be more willing to stipulate to lesser charges if the defendant's intent was in doubt. Moreover, in front of the jury, a defense counsel might find ways to invoke the spirit of the executive order without mentioning it by name. I hope nobody cites this in a motion against me, but I will certainly reference this in many ways other than the executive order in future jury trials. For example, you could argue the government itself recognizes that only those who knowingly break important rules should face criminal punishment, and then hammering that the client did not knowingly do wrong. One can imagine a bit of a culture shift in a jury selection argument, knowing that more than half of the people in this country voted for Donald Trump and seem to agree with his policies. They may also agree with overcriminalization efforts, and you can tap into that vein. At the margins, judges might be influenced by the broader climate. If the DOJ moves away from nickel and dime regulatory cases, a judge is likely to view the rare such case that still reaches the court with maybe a skeptical eye. Of course, they may assume that the case has been vetted and is not just a regulatory violation. From the perspective of someone facing a federal investigation for a regulatory offense, the executive order is cautiously good news. It means the chances of being criminally charged for a truly technical violation are lower. If you made an innocent paperwork error, your odds of being treated as a criminal are diminishing, but it's not a get-out-of-jail-free card. Importantly, the executive order explicitly states that it does not create any rights for private parties. In other words, you can't cite it in court as law. A stubborn prosecutor could theoretically ignore the policy, although they may get pressure from above. And of course, the executive order can be revoked or revised by this or future administrations. So love it while you've got it. A prudent defense counsel will treat this executive order as a helpful development and leverage where possible, but will still prepare their case as if charges could proceed. It would be a grave error to avoid preparing for trial because of this executive order. The safest course for clients remains, as always, full compliance because the laws and regulations on the books are still enforceable. Interestingly, the executive order's push for transparency could be a double-edged sword for defense attorneys in the longer run. Once agencies publish their shiny new list of all criminal offenses, ignorance of obscure and broad rules may be harder to claim, which is often a defense argument I make right now. Companies and regulated entities will essentially get a checklist of everything that could land them in criminal court. On one hand, that's great for compliance. You know what to watch out for. On the other hand, a published list could undercut a future defense that we had no way to know this was illegal. The executive order is basically telling agencies to shout these rules from the rooftops. A year or two from now, when those lists are public, a prosecutor could say, look, your offense is literally on the FDA's list of criminal violations that anyone can read on their website. You have no excuse for not knowing. Go to jail. In that sense, the executive order might strengthen the government's hand. Defense counsel will need to stay abreast of these published lists. They'll become required reading for anyone advising clients in any heavily regulated field. I will post them on the wall of my office and the offices of all of my staff. The first question a white-collar lawyer might get in a compliance review is, show me the list of criminal provisions for our industry, and let's make sure we're not violating any. So we should be prepared for that. All told, at the street level or boardroom level, the new policy should lead to a gentler touch for inadvertent violators, but a continued hard line for willful bad actors, which, as it should be. The executive order essentially tells the feds to use the velvet glove more and reserve the iron fist for those who truly deserve it. Let's look at some of the key areas of prosecution: healthcare, securities, wire, tax. The executive order's impact will not be uniform across all types of federal crimes. It particularly concerns regulatory offenses, which often overlap with what we think of as white-collar crime. Let me examine a few areas to see how they might be affected. Healthcare fraud programs or healthcare fraud prosecutions are usually related to healthcare fraud offenses when criminal defendants are charged. Federal healthcare programs, Medicare, Medicaid, are governed by complex regulations, and violations can lead to criminal charges under statutes like 18 U.S.C. 1347, the Anti-Kickback Statute, the False Claims Act. Some healthcare-related offenses are strict liability or close to it. For example, the Food, Drug, and Cosmetic Act, which I deal with heavily, makes it a crime to distribute misbranded or adulterated drugs. And under the Park Doctrine, corporate executives have been held criminally liable even absent proof of intent or knowledge, solely because they were in position of authority to prevent the violation. This means a pharmaceutical executive can be convicted of a misdemeanor basically for being the captain of a ship that wandered off course, even if they personally did nothing wrong. The new executive order is tailor-made to discourage such outcomes. It signals that prosecutors should not criminally charge minor or unintentional violations in the healthcare setting. For instance, if a hospital administrator failed to dot an I on a Medicare billing form, that shouldn't be treated as a federal fraud case. In practice, we may see fewer criminal charges for borderline cases like coding errors, record-keeping lapses, or technical non-compliance with health regulations, so long as they genuinely appear inadvertent. The focus will shift to deliberate schemes, blatantly billing for patients that didn't exist, or taking obvious bribes for referrals. Those truly fraudulent healthcare scams will still be charged, and rightly so, since they invoke knowing lies or theft. But when it comes to the murkier area of regulatory violations in healthcare, the executive order should tilt the balance towards leniency unless there is clear evidence of willful misconduct. Healthcare providers and administrators who often feel they're navigating a minefield of regulations might breathe a small sigh of relief if an innocent mistake is less likely to get you perp-walked. Instead, you might get a civil fine and a stern warning, and that's a far cry from an orange jumpsuit. Let's spend a little time on securities fraud. The world of stocks, trading, And the SEC has long had a dual system: civil enforcement by agencies and criminal enforcement by the DOJ for the worst violations. Go watch Wolf of Wall Street again, and I have a recent Substack on that and Section 230, which is quite hilarious, if I might say so myself. Many securities offenses hinge on whether a violation was willful. For example, willfully falsifying SEC filings or willfully violating the securities laws can trigger criminal charges under statutes like 15 U.S.C. 78. However, a great many SEC rules can technically be enforced as crimes, even if the matter is minor. It just usually doesn't happen because prosecutors exercise discretion. The new Trump executive order basically formalizes and emphasizes that discretionary line. We can expect that a small fry infraction, a startup missing a filing deadline, or a broker-dealer inadvertently breaking a minor trading rule will almost never be referred for criminal prosecution. Those would stay in the civil realm: fines, censure, etc. Criminal securities fraud cases will likely be reserved for the clearest cases of deceit and damage: Ponzi schemes, insider trading rings, multi-million-dollar accounting frauds, and so forth. In borderline scenarios, the executive order nudges enforcers to ask, did this person knowingly scheme to defraud investors, or was it a technical violation? Usually profit is going to drive that question. If it's the latter, no criminal charges. For example, consider the requirement that anyone acquiring more than 5% of a public company's stock must file a Schedule 13D. Failing to file a 13D can be a violation. It can't even be made criminal. Pre-executive order, if someone failed to do this, but they weren't engaging in insider trading or market manipulation, it might still draw a criminal inquiry, especially if prosecutors were looking at other areas and couldn't really make a case against you. Post-executive order, it's hard to imagine a DOJ going after such a person criminally. They leave it to the SEC to handle civilly. The executive order explicitly says criminal prosecution is most appropriate for those who knew what the rules were and intentionally broke them, causing significant harm. In securities cases, that basically describes your true fraudsters: Bernie Madoff, or folks who blatantly cook the books. The garden variety compliance slip-ups or gray area cases are not going to be prosecuted. This doesn't decriminalize securities laws. It just reserves the scarlet letter of criminal for the worst actors, not every violator of SEC rules. In practice, DOJ is already selective with these cases, but the executive order doubles down on selectivity. One note: truly egregious securities fraud, like knowing insider trading, pump and dump schemes, already require proof of intent and will continue to be pursued vigorously. Probably no change there. Let's talk about wire fraud and other general mail fraud. These are the types of catch-all frauds that we see. It's a bit of an odd duck in this situation because it's not tied to any specific regulation. It's a broad statute that makes it a crime to scheme to defraud someone using wire communications. But prosecutors love it, particularly because it's not tied to a regulation. It's famously referred to as the prosecutor's Stradivarius because of its versatility. At first blush, one might think that an order about regulatory crimes has nothing to do with wire fraud, and largely that's true. Wire fraud already requires criminal intent. You can't accidentally commit wire fraud. So the executive order's emphasis on mens rea doesn't change the legal elements if someone's committing wire fraud. But we have to look at the definition of fraud. A wire fraudster is somebody who knowingly violates not just a regulation, but a core criminal statute and causing harm by defrauding victims. So wire fraud cases shouldn't go anywhere, unless, of course, the DOJ charges wire fraud instead of violation of a regulation. You likely won't see the DOJ suddenly saying, oh, we won't charge wire fraud because maybe the schemer didn't realize what he did was wrong. That just doesn't fit the wire fraud statute. The schemer always should know. But there's a subtle way that the executive order could touch cases that include wire and mail fraud charges. Often in a large scheme, prosecutors tack on these fraud charges as catch-alls to add a 20-year statutory maximum to the case, even when the scheme involves violations of other regulations. For instance, suppose a company violates FDA regulations in how it markets a drug, and it also sends emails to doctors with misleading info. That could be charged as wire fraud and also involve the regulatory violation, or even conspiracy and involve the regulatory violation. Under the new policy, the DOJ might be a bit more discerning in such hybrid cases if the only harm was a violation of an FDA rule and no one actually defrauded in a traditional sense. They might skip the wire fraud indictment and leave it as a regulatory matter, which could be a 5 or a 10-year crime as opposed to a 20. But if there was deceit to obtain money or property, then it's classic fraud and will be charged. Let's briefly talk about tax fraud. Usually these have a mens rea attached to them. Almost all tax fraud cases, crimes, statutes have a built-in willfulness requirement, meaning the government must prove the defendant intentionally violated a known legal duty. In theory, the tax arena has always embraced the mens rea principle. You're not supposed to become a criminal tax felon for making a mistake on your 1040. You have to willfully cheat or lie. Because of this, the executive order may not dramatically change tax prosecutions. They're already focused on knowing evaders. There's just too many cases out there if they don't. The IRS and DOJ tax divisions don't usually prosecute mere negligent errors. That being said, though, the tax code and IRS regulations are voluminous, and so this could have an impact on the regulations in the sense that if there's no mens rea, they may not be considered criminal violations. One example here is failing to file FBAR, Treasury Form for Foreign Bank Accounts. We've seen that charged as criminal if willful. The executive order's spirit would suggest that unless a person clearly tried to hide money offshore and knew they had to report it, prosecutors should hesitate to charge them criminally for paperwork faults. Routine tax evasion cases, say a business owner systematically underreporting cash income, will continue to be bread and butter prosecutions since those involve intentional deceit. The executive order gives no quarter to those folks, but we might see a touch more mercy in edge cases. For instance, if someone's tax violation stemmed from relying on a genuinely confusing IRS regulation or good faith misunderstanding, the executive order provides rhetorical ammunition to treat that scenario leniently. Again, a lot of this is already how things operate, but now it's enshrined in policy. So if there's any corner of tax enforcement where strict liability or obscure rules lurk, those will be approached with caution. In each of these domains, the pattern is the same. Knowing intentional wrongdoing equals still criminal. Inadvertent or technical violations, presumptively not criminal. The effective order draws a big red line that says, cross this only if you're sure someone really deserved to be branded a criminal. Now, let's talk a bit about congressional action, and then we'll wrap up. The executive order, like all, operates within the confines of existing law. It doesn't and can't repeal any criminal statutes or magically erase the criminal penalties from regulations that Congress has enacted. Only Congress itself could fundamentally reform the federal criminal code and the sprawl of regulatory crimes. So how is Congress likely to respond to Trump? The short answer is with a shrug, at least publicly. They're not generally known for rushing to roll back laws once passed. There's little political glory in repealing crimes or streamlining the code, and plenty of risk. Who wants to be accused of being soft on crime? However, beneath the surface, there's some bipartisan awareness of the overcriminalization problem. In fact, even before this executive order was issued, lawmakers from both parties were pushing for modest steps in the same direction. Surprisingly bipartisan. In March 2025, a bipartisan group in the House led by Chip Roy from Texas, along with Reps. Lucy McBath and Andy Biggs and Steve Cohen, introduced the Count the Crimes to Cut Act of 2025. It would require the Attorney General and all agencies to compile a comprehensive list of federal criminal offenses. So Trump was obviously taking some bipartisan language. In other words, Congress is telling the DOJ to do exactly the inventory that Trump is requesting through the executive order. The fact that both legislative and executive branches came up with the same idea shows a growing consensus. We like it. Almost any adult in this country could be indicted for some kind of infraction at any given time, whether or not they are even aware they were in violation. Strong words, and notably coming from a Republican, but echoed by Democrats like McBath who support the bill, create a very strong voice. The goal here is modest. but certainly a valiant one. President Trump's latest executive order tackling the overreach of criminal and regulatory offenses is inspiring and relatively sobering. It's inspiring that it acknowledges a serious problem that's plagued America and been a huge concern during my professional career. The incredibly complex patchwork of statutes and regulations is just nonsensical to the average American, not to mention any immigrant coming to this country to try to make a life for themselves. The executive order takes a meaningful step towards restoring sanity and fairness, emphasizing that people shouldn't be prosecuted for violations they don't know about and didn't intend. The order's a clear rebuke to the overzealous regulatory state and a signal that at least one branch of government is interested in reining in the madness. In that sense, it's a welcome reform. Defense attorneys, compliance officers, ordinary citizens in the heavily regulated fields all have a reason to cheer this new policy. It promises a future where grandpa won't go to federal prison for accidentally mislabeling pigeon feed. Yeah, that's a crime too. And yet, in true Beltway fashion, the reform is also insufficient. It's a bit like using an executive order to direct the tide to roll back. The effort's commendable, but the underlying forces are vast and largely outside of one person's control. The executive order does not repeal a single criminal law or regulation. All those obscure statutes and rules will stay on the books. The executive branch can choose to ignore or de-emphasize them, but Congress must take some action, and we will be patiently waiting until the cows come home for them to do so. Some critics might argue the executive order has loopholes or unintended consequences. I don't see any. This is pretty common sense constitutional stuff. There's not a lot of room for argument with this unless you just simply do not like Donald Trump. Let's not kid ourselves. This is not the ultimate cure. Let's not take an applause. There's still a lot of fighting to do. One might say that we're all just trying to make it through the water without getting locked up for stepping on a regulatory landmine. Trump's order at least puts some warning signs in front of us. It's a welcome relief, but until Congress and the broader legal system addresses the root causes, the overproduction of laws, we are still going to get more laws on the books, and they are continuing to be very complicated. So raise a glass to this executive order. It's a good thing. Might keep a few decent folks out of prison and make prosecutors think twice before wielding the sledgehammer of criminal law. It might go a little further towards enforcing our Constitution, but there's still a lot more progress to do. I'm Ron Chapman. Thank you for joining me. I hope that this was fulfilling and interesting, if not a bit dry. And in the next episode, I believe we're going to have something about Section 230, which is probably one of the most damaging laws on our books as far as I can see, and has the most far-reaching effects.